Okay, well, good evening, everybody. For those of you who have come from outside of the university and don't know me, I'm Professor Mark Ormerod. I'm Deputy Vice-Chancellor and Provost here at Keele, and it's a great pleasure to welcome you here this evening for tonight's inaugural lecture. I'd also particularly like to welcome friends and family of tonight's inaugural Alison and also professional colleagues from outside the university. So the role of inaugural lectures at Keele are probably twofold. Firstly, a chance for the new professor to talk about their area of expertise, and secondly to profile research at Keele as a research-led institution and also research in the discipline. And before I sort of pass over to tonight's speaker, I'll just say a few words of biography around Alison. So Professor Alison Brammer studied law at Sussex University before qualifying as a solicitor. She then practiced as a local authority lawyer, specialising in work with social services before coming to Keele as a lecturer in law. Alison was subsequently promoted to senior lecturer and then to professor in 2016. Alison's been at Keele quite a long time, and in that time she has made a tremendous contribution both to the School of Law and more widely across the institution. She's led the innovative interdisciplinary masters in childcare law and practice, and she developed a new master's programme in safeguarding adults, law, policy and practice, alongside teaching law across social work programmes. Her research publications include Social Work Law, which is now in its 4th edition, Safeguarding Adults, and an edited collection, Critical Issues in Social Work Law, with Keele colleague Jane Boylan, who's here tonight. Alison's the series editor of the Social Work Law Focus series of 14 specialist texts for social workers, which includes her own volume. She's legal editor of the Journal of Adult Protection, and she writes a monthly column in Professional Social Work. Alison's developed a research profile across the broad area of safeguarding, addressing both children and adults, and the themes of her work include conceptualization of abuse and safeguarding responses, including contributions to debate on the scope and role of legal intervention. With a focus on the disciplinary boundaries between and across law and social work, she has led the development of a number of important interdisciplinary, multi-institutional collaborations. During her time at Keele, Alison's attracted significant competitive research funding, and her current research projects include an ESRC, so Research Council seminar series on the implications of the CARE 2014 for safeguarding adults in civil society, and an ongoing study of mothers who have had children removed from their care, which is funded by the British Academy. Alison's worked extensively with local and health authorities, offering consultancy and bespoke knowledge transfer work, and her research has had a significant impact outside of the academic environment. She's very much committed to promoting and enhancing the professional profile and expertise of social workers through innovative education and training across the full range of learning and career development stages, and as a trustee of the British Association of Social Workers is working with them on a framework for continuing professional development. In 2015 she was awarded a senior fellowship at the Higher Education Academy, and she's been nominated by the university for a National Teaching Fellowship. And then in 2016, top of all that, Alison took on the responsibilities of head of the School of Law. So can I therefore formally welcome Alison Brammer, Professor of Social Work Law and head of the School of Law, and invite her to present her inaugural lecture, Viewing Safeguarding Through the Lens of Legal Literacy.
Well, thank you very much for that kind introduction. Good evening, and thank you all for being here and for your interest and support. I'm really quite overwhelmed. So, I think I'm known, at least within my family, for a degree of procrastination. Hence, I managed to secure the final slot in this annual inaugural lecture series. But by happy coincidence, today is also World Elder Abuse Awareness Day, a subject close to my heart and which I'll touch on this evening. And over the years, I've generally taken part in some sort of activity to mark the day, even if it's just eating cake somewhere. But one organisation, Action on Elder Abuse, has really led the way in the UK in raising awareness, and I've had the pleasure of working with them on many occasions. So although it's a little unconventional, I've taken the liberty of placing some of their collection boxes outside next to the wine to mark the day and to recognise the need for ongoing work in this important area. So if you feel able to contribute, I, and particularly Action on Elder Abuse, would be very grateful, and it would make this all worthwhile. So, as you've perhaps heard a little of, and like most people who find themselves delivering an inaugural lecture, I rather drifted into academia. It was a bit of part-time teaching after Faith was born. Before that, as a law student, my ambition was very much to work in the law, in the community, and make a difference. And I was influenced by a couple of spells working in a law centre. That led to me taking articles and a first post as a solicitor in a local authority, where the social services caseload really appealed to me the most. Of course, I didn't realise then that I would spend most of my working life with social workers, and that I would have aspects of that role and its interaction with the law at the forefront of my teaching, scholarship and research. So it's not surprising, perhaps, that today I want to talk about that intersection, the relationship between social work and law, and the symbiotic relationship between social workers and lawyers in regard to what has become an important area of social work practice, safeguarding. And of critical importance in safeguarding, the social work understanding and application of law, which is loosely referred to as legal literacy. The lecture will draw on my research across quite a wide range of projects from over the years, and with a focus on those two central aspects, safeguarding and legal literacy, and will be illustrated by voices of social workers, of local authority lawyers and students, and also via case law of judges. So a little bit of context to begin with. Safeguarding has emerged as a really significant area of social concern, accompanied by significant policy and law reform over the last 30 to 50 years. It's a major, if not the major, area of practice for social workers, both in relation to children and to adults. And at Keele, that's reflected in two popular master's courses. It's been my privilege to lead both and to have developed one. And the students from those courses have contributed significantly to the safeguarding research base. And you can see there, this is how happy the first graduates of the Safeguarding Adults programme looked. My focus today will be mainly on adult rather than child safeguarding. Much of what I will say about legal literacy would apply equally to childcare, and some of the case law I will cite regarding social work practice is child-based. But it's important to acknowledge that in any discussion of adult safeguarding, whilst a great deal of practice there has drawn on the children's model, there are significant differences as well as similarities. At times there is convergence given the growing awareness of safeguarding at the interface between adults and children's services responsibilities, especially at times of transition. And I'm also proud to say that in relation to children's and adults safeguarding, these feature prominently in two new research centres at Keele as critical themes in KPAC, the Keele Policing Academic Collaboration, and in KCAR, the Keele Centre for Ageing Research, and I have some involvement with both of those. The other area then that has occupied much of my time here is teaching law to non-lawyers, principally social workers, and I hope that my research and scholarship has made some contribution to the recognition of an emergent discipline, social work law, including the establishment of the Social Work Law Association, which is led from Kiel as a national organisation of academics and educators in social work law, as a centre for pedagogical development and innovation, and we have approaching 100 members now. So the driving force behind this work is commitment to legal literacy as a means of empowering social workers and raising the professional profile of social work. Both my interest in safeguarding and legal literacy are a natural progression from my work all those years ago as a local authority solicitor, and that role also features in my discussion today as a bridge between safeguarding and legal literacy. So I'm going to start with safeguarding. My interest and research has concerned the conceptual, defining abuse and safeguarding, and the more practical and applied, the role and application of law, including the case for imaginative use of law. It's an area of practice, policy and law that is expanding in every sense, characterised by growth in awareness, prevalence, typology, professional involvement, policy and legislative attention. There are few bodies or organisations that don't have a safeguarding policy. It truly has become everybody's business. But the fundamental responsibility for safeguarding, and at times the blame, rests with social workers on the front line. Adult safeguarding has experienced a heightened awareness and greater policy prominence following publicised failures in practice to identify and protect, for example, in relation to Stephen Hoskins and Winterbourne View, which according to Scragg and Mantell mirrors the public and professionals' discovery of child abuse in the past, with increasing scrutiny being paid to abusive situations by the media, by researchers and by practitioners. So currently, the Care and Support Statutory Guidance of 2014 defines adult safeguarding as protecting an adult's right to live in safety, free from abuse and neglect. That's our starting point. But I want to track back with a brief summary of the evolution of adult safeguarding, from which three key themes emerge: questions of definition, professional responsibility, and outcomes. Tracing a series of guidance documents, it's possible to discern a steady expansion of the phenomenon. Initial policy reflected a clear domestic and institutional divide. In No Longer Afraid, the safeguard of older people in domestic settings, the first formal definition appeared, limiting policy in relation to setting, into domestic settings, and subject, older people, but silent as to the perpetrator. And this was despite growing awareness at the time of institutional abuse. So you see the definition there. An action on elder abuse definition was commissioned in the following year, but was also problematic with reference to relationship of trust, excluding abuse by strangers. Elder abuse is a single or repeated act or lack of appropriate action, occurring with any relationship where there is an expectation of trust which causes harm or distress to an older person. In 2000, No Secrets offered a different approach. Abuse is a violation of an individual's human and civil rights by any other person or persons, reflecting an alternative conceptual basis, coinciding with the introduction of the Human Rights Act and not limited to relationships of trust or to particular settings. On closer examination of the document, the subject of abuse must fit the description of a vulnerable adult, not limited to older people, and extending to adults from the age of 18, including those with physical disability and mental health problems. Clearly not a cohesive group, argument that some categories should be separate from the wider discourse that is safeguarding, for example, elder abuse, recognising the impact of ageism, continues to be made by, amongst others, Jonathan Herring. An opposing view suggests that this carries the risk of developing a hierarchy of categories of vulnerability that might be linked to resources. As the lead agency bound by No Secrets, social workers working within local authorities were urged to know and use the law, an implicit reference to legal literacy as the means to achieve effective adult safeguarding. Following No Secrets, we see a shift away from the vulnerable in language, away from the vulnerable adult towards greater emphasis on risk, and from adult protection to the more inclusive and expansive term safeguarding. During this period, practice and policy had developed in the absence of a precise legal framework, but including shifts towards personalisation. The CARE Act then, as the next milestone in this journey, with the inclusion of statutory safeguard provisions for the first time, marks a new era in this evolving field. Any reference to a vulnerable adult has been removed. Rather, the Act speaks of adults with care and support needs, whether being met or not, casting a very wide net. Extended categories of abuse beyond those listed in No Secrets were included in the statutory guidance, with the specific addition of domestic violence, modern slavery, organisational abuse, and self-neglect. Of course, this clear categorisation of abuse is rarely presented in the complex reality of adult safeguarding, and contrasts with Cambridge's view that multiple abuse is a closer reflection of everyday practice, and with exploitation as a common theme. The new categories notably represent a considerable extension to the boundaries of safeguarding practice and potentially incorporate scenarios that are unfamiliar to social workers, require expertise of bodies hitherto excluded, and require a range of different, including legal, responses. The breadth of types of abuse provided by the extension of categories arguably represents the demise of any meaningful definition of adult abuse, to the extent that safeguarding has become an amorphous concern. And this scope was echoed in comments from one of the local authority lawyers that I interviewed when asked to define the ambit of their social work, their adult safeguarding work. She said, "It's everything but childcare. I mean, the list goes on and on. It's one of the most complex and wide-ranging areas of law." So definitions of harm and abuse have been at the centre of research and policy focus, but they must be operationalised by practitioners. And as safeguarding is characterised by growth in terms of remit, expansion is also evident in relation to professional involvement, with more emphasis on a multidisciplinary approach supported by a duty to cooperate. Perkins et al. Note that lack of clarity about roles and responsibilities, resource pressures, lack of commitment of some agencies, and insufficient information sharing can hinder a multi-agency approach, though shared expertise and a sense of shared responsibility is generally considered a strength. But in this multidisciplinary landscape, the relative absence of one player, the local authority lawyer, is notable. From the guidance, which runs to over 20 chapters, there are just these 3 references, and they themselves are somewhat veiled. So line managers should have access to legal advice, but not mentioning specifically the local authority lawyer. When they're taking cases to the Court of Protection, chief officers should receive regular briefings of case law. The board should keep policies and procedures under review, and they should include the provisions of the law, criminal, civil and statutory, and information about obtaining legal advice. Any assumption that social workers and lawyers as representatives of the local authority are united and indistinguishable oversimplifies the position and doesn't reflect the reality of 2 separate but complementary roles. The invisibility of the local authority lawyer is reflected also in research terms. Accepting Dickens' work, which has a child protection focus, and Swain, who referred to an uneasy marriage, the relationship between local authority lawyers and social workers is largely underexplored, though integral to safeguarding. Turning to outcomes as the third key theme in safeguarding. Social workers use their professional judgment to apply the legal tests for inquiry triggering action that may lead to further legal intervention to secure desired outcomes. Beyond the duty to make inquiries, the range of legal options to secure desirable outcomes requires extensive legal knowledge and interprofessional practice. It's complex to navigate, and some time ago I suggested a model to navigate legal options depending on type of abuse, desired outcome, level of intervention characterised as preventive and regulatory, autonomous decision-making and state intervention. And those are strands that are all reflected in this formal position, identifying a range of possible outcomes. Action might be primarily supportive or therapeutic, or it might involve the application of civil orders, sanctions, suspension, regulatory activity or criminal prosecution, disciplinary action or deregistration from a professional body. Safeguarding is becoming an increasingly legal domain. And just to pick one of those possible outcomes, my research into prosecutions for the offence of ill treatment and willful neglect, which was introduced into the Mental Capacity Act, and is the closest to a specific crime of adult abuse, found confusion as to the meaning of capacity in a criminal context and paltry sentences supporting Manthorpe's view that adult safeguarding is firmly located in a welfarist discourse. And there's a whole other debate about the perception of abuse as crime. These are some examples from that particular research, and I'm going to just leave that up to give a sense of the reality of adult abuse. So currently, the Care Act provides a framework for safeguarding practice in which knowledge and confidence of the law by those charged with its discharge is critical and informs the exercise of professional judgment. That's the essence of legal literacy. The challenges of interpretation, learning and application of the new law, breadth and diversity of relevant law beyond the Act, and speed of implementation combine to heighten pressure on practitioners delivering social welfare services to become legally literate and push the boundaries of what legal literacy looks like. So to a closer examination of legal literacy, what is it? It surprised me really when preparing for this and carrying out research to find that legal literacy carries a range of meanings and certainly isn't confined to the domain of social work. So Axfoltz talks about it being a term utilised broadly as a spectrum concept. For example, in the context of law librarianship, it provides a succinct and powerful statement of purpose, a core identity. And in social work, it also contributes to that professional identity. It can extend to professional protection, whereby a professional group may benefit from knowledge of the law relevant to their particular practice, such as the medical profession and negligence perhaps, individual employment law rights and whistleblowing. And according to Grimes, legal literacy is encompassed in the aim of street law programs to promote higher levels of legal literacy in the community as a whole by promoting a clearer understanding of rights and responsibilities. Legal self-help, increasingly relevant today alongside the growth of litigants in person. And this also resonates with an aspect of the social work role as a conduit to and translator of legal knowledge. For social work, legal literacy is more than the ability to read, write and understand concepts of law, the information of law. It also captures knowledge and skills necessary to function as a professional with legal powers and duties, a mandate to practice, within a framework of social work values across a range of settings, including courts. So as well as setting parameters, there is an ecological aspect as social workers operate within the legal system as part of that environment. And there are a range of other fuller explanations, descriptions, quotes of legal literacy, and I've put this one up from Lord Justice Andrew McFarlane, who's now a Court of Appeal judge, and I've put that one up particularly because my former colleague and good friend Trish is here tonight, and we worked together many years ago at Shropshire County Council, and we used to instruct Andrew McFarlane, who was then a barrister at number 5 Chambers, and he used to carry our bags for us. So that's quite a special one to me. But in essence, he talks about the need for understanding of the law, the framework that it provides, the protection that it can provide, the empowering nature, and also stresses its application. Moving on, I think the Care Act is a catalyst for a more nuanced interpretation of legal literacy. So to move beyond technical knowledge of the new law to a more critically informed and reflective understanding, which will support the implementation of underlying principles for safeguarding practice. There are layers of analysis that legal literacy as an interpretive tool can drive. And this model is the focus of the ESR seminar series, which is currently being led from Keele with colleagues from a range of universities and practitioners, reflecting the inter- and multidisciplinary nature of safeguarding. In this research series, we offer an analysis of the new safeguarding framework provided by the Care Act through the lens of legal literacy, exploring 3 levels: making law, the origins of the new law, interpretation of the new law, including the interface and connection with human rights, equality, mental health and capacity legislation, and the challenges of learning and implementing knowledge of law in practice. The value of legal literacy crystallises in the legal arena, where social work and the intersection with law falls to judicial scrutiny. And a few case law examples are illustrative. So in Coventry, where consent to the removal of a child was improperly obtained, Justice Headley gave specific direction to the social worker in the case as to how capacity to consent should have been assessed. This also illustrates the breadth of legal literacy, with the need for social workers in child protection to have an understanding of capacity law in relation to an adult. And then in the well-known case of London Borough of Hillingdon and Neary, which concerns Stephen, a 20-year-old man with autism, action of the local authority in preventing his return to his father's care after a period of respite amounted to breaches of Article 5 of the European Convention, also Articles 6, 8 and 10. The consequences can thus be costly on a number of levels for individuals, but also for the council. So in the Essex case there, where unlawful deprivation of liberty of a 91-year-old for 13 months led to an award of £60,000 damages against the council. And for the impact on the individual social worker, Costa, who was working in adult social care, was struck off by the Conduct and Competence Committee by reason of lack of competence, such that fitness to practice was impaired. And in particular, he demonstrated a lack of basic social work knowledge, including a lack of understanding of the relevant legislation and or legal basis for social work, amounting to an unacceptably low standard of professional performance. Further examination of case law reveals strident critique of social work practice by judges, arguably an imperative to raising the importance of legal literacy, but stoking the tension between law and social work. So in relation to social work evidence, Lord Justice Mumby, as he was then, refers to sloppy practice. And in the Cheshire case, a reference to social work which was at best lackadaisical and at worst is in plain contravention of the applicable statutory guidance and long-established good practice. Thankfully, there are also encouraging comments and recognition of good practice. The evidence of a social worker was preferred to that of a consultant neuropsychiatrist in assessing the capacity of a man with Huntington's disease in PH. And there has been recognition of the complexity of the role in the Davis case that's listed there, which involved failure to follow safeguarding procedures, including the conduct of a case conference. The professionals in this case acted throughout in good faith and having in mind the best interests of those they're engaged to protect. There are obviously great pressures on local authority employees carrying out this important and stressful work. The consequences of a failure to intervene can be grave. Those working in this area face criticism for allegedly interfering when they intervene, and for alleged neglect or worse when they do not. So the classic social work dilemma, damned if you do, damned if you don't. And further support at the highest level from the president of the family division, who simply said social workers are expert. Another source, evaluation of reflective learning on legal literacy, suggests that there can be direct benefit to service users. So here's some quotes from students' reflective accounts. In the first one, a recognition of the need to consider human rights. So in practice, I do not believe rights were violated or not considered in my investigation, although I feel in future more emphasis is needed in my practice on their rights. Secondly, I feel this incident marked a new beginning in my awareness as a safeguarding practitioner. Due to the learning in the first module, I felt confident to challenge the social workers and her manager's dismissal of a vulnerable adult and assert that it required some level of investigation. Finally, I've reflected on my approach to this case. I think I'm acting more informed law questions. I seem to have better insight. So if there is both a call for and some benefit to a commitment to legal literacy in safeguarding, the obvious next question is how this is to be achieved. Formal development of legal literacy begins as part of the social work qualification programme, as required by the professional body. But beyond the first stage, Preston Shute and McKim observed that achieving and maintaining legal literacy is challenging, in particular keeping pace with the growth of relevant law alongside the demands of active and usually increasing caseloads. And Bray cautions, students' understanding of law decays over time when their knowledge is not routinely used. The social work qualification involves time on placement, and here a particular role is important, the practice educator, at the interface between social work students' understanding of law from classroom-based learning and its application in a practice context, experiential learning. And some research conducted with Jane again explored both how the practice educator supports students learning legal literacy, and how they themselves are supported. A potential knowledge gap in terms of the expectations of the profession and the learning needs of practice educators became apparent, as captured in these quotes from the practice educators. My fear is that I'm unconsciously incompetent about the law, and that's based on a couple of experiences where I've said, oh, you should be able to do this. The law says you should be able to do that, but really where it's not been right. So I guess I feel like I know things from my past experiences of learning about things, and they're not necessarily true. You start to read the stuff and it's so dense and you can't, you haven't got the time actually. And I know that, a little learning is a dangerous thing, but it's useful to be challenged into where you can find stuff that you need to know. And thirdly, but I'm also relying on the student who's been in university to bring their knowledge. It'd be lovely if I knew far more than them around that, but I don't. I'm being really honest. So the relationship and knowledge exchange might be described as reciprocal, and the reliance on practice educators support legal literacy might be somewhat displaced. Once qualified, the obvious vehicle to counter this decay and to promote confidence in using law and practice is the undertaking of continuing professional developments. And comments consistent with that approach emerged with the Family Justice Review, which featured a recommendation that social work practice prior to and during court involvement should be enhanced, and this should be implemented through guidance and continuing professional development. In response, we were commissioned by the College of Social Work to produce a CPD curriculum guide on court skills, but it remains the only area of social work practice where such guidance exists, and unfortunately, as the College of Social Work was disbanded, even this archive is somewhat hidden. This guide is archived. So, further support for ongoing legal learning, you would expect to be driven by the professional bodies for social work. But in fact, their response has been disappointing, and it really vests responsibility in the individual social worker. And it seems there is a missed opportunity here to formalise an expectation of ongoing professional development that would both empower and protect social workers and arguably result in raised standards of practice. Turning to the law again, the courts have given a clear signal of an organisational responsibility for legal literacy, and a commitment to workforce development is called for beyond that onerous responsibility at individual level. So in the case of G&E, which was again a deprivation of liberty case, where the court was so critical of the local authority that it named them as an aspect of accountability, the judge said, "I formed a very clear view that the responsibility for what had gone wrong rested at a much higher level within the local authority, and that one of the most damning criticisms of the council in this case was that it had seemingly failed to provide any adequate training to its staff to prepare for the radical changes introduced by the DOL's provisions." And in another decision, where a social worker was giving evidence in court, I also questioned the support offered for his preparation for court, his understanding of the legal process and appearance before me. So that responsibility for support extends beyond knowledge of the law to skills in operating within the law. So I hope I've made something of a case as to the value of legal literacy and highlighted the challenges in realising underpinning legal literacy for safeguarding practice, particularly the expansion of safeguarding and the complexity of the legal framework, together with limitations regarding CPD opportunities. But barriers to legal literacy and effective implementation of the new law may run much deeper than those very practical issues and stem from a tension between law and social work. And this forms the closing section of the lecture. It's a tension evident in my early experiences of teaching by a resistance to and anxiety about the study of law and a perception of law as restricting and constraining practice, itself discriminatory. It's apparent at discipline and professional level that this tension may be traced to differences between law and social work that go to the ideological and historical roots of the two professions. Whereas law is one of the oldest professions and academic disciplines, social work is comparatively young in the professional and academic sense, with relatively recent formal legal status, with the term social worker becoming a protected title as recently as 2001. It's also argued that there are contrasting values at its extreme, with social work focusing on care and rehabilitation and law emphasising punishment and deterrence, and a social work approach characterised by consensus, contrasting with adversarial lawyers. So perhaps not natural companions, a position that's reflected in stereotypical images, with lawyers often portrayed as middle-aged, men, suited and stern, in contrast to images of social work that's really captured in pictures of people holding hands, trees, and wearing sandals. And I stress that these are stereotypes. Upset all the social workers now. Finding an image for the intersection between social work and law is also testing, as my best attempts might show. Over the years, I hope to have made some progress, though, away from the tension of the frayed rope in my first edition and edging towards a light bulb moment in the fourth. Of course, the tension between social work and law may also be rooted in differences in education. Historically, legal education was predominantly textual and social work more experiential. And Taylor suggests further differences in content, environment, and educational techniques. Again, I couldn't resist this article title by Nelken. If I'd wanted to learn about feelings, I wouldn't have gone to law school. Of course, that's not how we do things here. Recent changes building on the process of professionalisation of social work, the legal regulation of social work, structured academic training, and ethical codes for both professions, shared skills such as advocacy, suggest that far from having irreconcilable differences, there is commonality and a shared orientation to the work of problem solving at times of crisis in individual lives. Such that Doran says that social work and law have undergone a process of professional convergence in recent years, with an ideological shift of both professions towards the human rights-oriented discourse. For the local authority social worker engaged in safeguarding, the tension between social work and law, between social workers and lawyers, has the potential to frustrate an important working relationship with the local authority lawyer. A strategy to promote legal literacy that includes some reconceptualization of the interprofessional relationship with lawyers, with a more fluid interpretation of the traditional lawyer-client relationship, has the potential to strengthen working practices in safeguarding. Interprofessional education and understanding that challenges values and attitudes and promotes understanding of roles can clarify working parameters and expectations, overcome role conflict and confusion, but also underpin a more nuanced and flexible interpretation of the advise and instruct model. And my interviews with local authority lawyers would support that. As in a response to the question, is the role clearly one of giving legal advice? This particular lawyer said, maybe that's an aspect of local government in-house work that is possibly slightly different from purer legal work in private practice. But I think it's very much teamwork. And we're employed by the council, so we have a vested interest in making sure the case works well, rather than just dealing with our instructions and taking it on from there, if that makes sense. And social workers will often look at us and appear to want some guidance on what the care plan should be. And although I do resist that in a formal way, I'm very happy to. Having said it is your plan, you'll be in the witness box defending it. Having said that, I ignore my own advice and will happily talk about the care plan for the rest of the day. The blurring of advice on casework as opposed to pure legal issues was a constant theme in these interviews, and suggests that the local authority lawyer, largely invisible in the multidisciplinary partnership, may in fact be the invisible ally of the social worker in safeguarding. This extends the notion of legal literacy beyond knowledge and skills acquisition and application to relational legal literacy, where legal knowledge is important, but so too is the relationship with lawyers. Effective implementation of the Care Act and associated provisions depends on critical engagement and understanding of the process of lawmaking, on legal literacy on the part of all disciplines involved, but particularly social workers. Achieving and maintaining legal literacy is challenging, and in the absence of clear direction and support from the social work professional body, responsibility has rested with the individual social worker. A reinterpretation of legal literacy as relational in acquisition and application offers a positive way forward. The last word to a solicitor. when asked, what are the key challenges of this area of work for social workers and lawyers? Talked about dealing with the increase in volume, but with the knowledge that the potential consequences of something going wrong in this area of law can also be potentially very serious. It's not like you're dealing with an area of land or a commercial or non-contentious matter. You're dealing with people's lives at the end of the day. And so the consequences can be very serious if you don't get things right. So it's trying to get things right, as right as possible, as often as possible. Now, that wasn't quite the last word. I think it will be apparent that I have a huge respect for social work as a profession, and I want to start a few thank yous by thanking all of the social work students, now practitioners, that I've had the privilege to teach, for their enthusiasm and commitment to social work. And social work colleagues have also been very important to me. At times, I think I've had a closer affinity to that school than to law. I particularly want to mention Jane, who's been often my travelling companion. Here we were in India, and also a collaborator, although we got a bit distracted when we went to the University of Lapland. This promotion, I wouldn't be standing here. I never thought I would be standing here. This promotion wouldn't have happened without the support of Andrew Francis, who's there, and former head of school, and David Shepherd, former dean, here in the eminent company of the president of the family division at the silver anniversary of Charter Law and Practice. And of course, I'm grateful to Shane O'Neill for his ongoing support since my career has taken another path as head of school. In that role, I've seen students and colleagues in a different light. I can say that I work with some remarkable, interesting and collegiate staff. Here we are on one of our lovely Wednesday coffee mornings. Two people from that staff group deserve particular mention. Sarah Lane, senior school manager and the heart of the school. I simply couldn't do my job without her. And also Calvin Johnston, long-term colleague and friend across Charter Law and Practice, safeguarding adults and social work, and always there for me with wise counsel. I've also had much more contact with law students since becoming head of school as opposed to social work students, and they are a constant source of inspiration and obviously the most glamorous in the university. But the most important relationships that have sustained me and enabled me to work as I do are, of course, my family. So thanks especially to them for coming today, to my parents for instilling in me their love of education and for everything else they've done for me. To Dave for his constant support, encouragement, and increasing tolerance when he would really much rather I was out cycling or walking up a hill than working. And finally, Faith, Elliot and Lawrence. Having grown up whilst I've been at Keele, it's perhaps not surprising that they haven't chosen law or social work. But in every sense, I couldn't be more proud of them. Thank you.